Welcome to the Lawyer Education Series. My name is Katie Kelso and I'm the Solicitor in charge of Care and Protection at Legal Aid New South Wales. I've appeared as a children's lawyer in the Children's Court, District Court and Supreme Court in New South Wales. I'm pleased to present this training on representing children in care and protection matters. I'm joined by Magistrate Nell Skinner of the Children's Court of New South Wales.
Thank you, Katie. It's a privilege to work with children and families in New South Wales, but with privilege comes responsibility. We're responsible for making decisions that affect the lives of children, and in exercising that responsibility, we endeavour to make the best possible decision for each child. We are reliant on committed, diligent and compassionate legal practitioners placing evidence before the court to ensure we have all relevant information to assist us in making the best decision for each child. There are no shortcuts. Everything you do as an independent legal representative or direct legal representative can affect outcomes for the child you're representing. On behalf of the court, the community and every child whose name is on a file in our care jurisdiction, please do the job properly. The purpose of this training is to remind you about what it means to do the job properly. It is a valuable and important role.
Thank you, Magistrate Skinner. I'm also joined by Jane Christian, who is an Aboriginal lawyer in the Family Law Division.
Thanks, Katie. Before we begin, it's important to be aware of the historical issues around child removal, particularly in relation to the stolen generations. Since the 1800s, Aboriginal children were forcibly removed from their families as a direct result of government laws and policies. This happened in my own family. Children were placed into homes like the Kinchilla Boys Home, the Cootamundra Girls Home, and institutions, or fostered and adopted into non-Indigenous families. For many generations, Aboriginal children were disconnected from their family, community, identity, land, language and culture, all the important things that make you who you are. This practice led to widespread intergenerational trauma in Aboriginal families and communities. Some people consider that the stolen generations never really ended and continue today in the current care and protection system, because children continue to be removed from their families at higher rates than non-Aboriginal children. Even though Aboriginal children make up 5.5% of the total population of children in Australia, over a third of children in out-of-home care are Aboriginal kids. Legal Aid is a major provider of family law services to Aboriginal people in New South Wales, and you may assist many Aboriginal families, so your awareness and commitment to learning about these issues is vital to your practice.
For me, representing children can be an incredibly challenging part of my job, but it's often the most rewarding. Representing children can be difficult work and it requires an entirely different skill set to representing parents. This training will take a closer look at child representation in the care and protection jurisdiction. We will be covering the following topics: representing children in care proceedings, the principle of participation, Aboriginal and Torres Strait Islander specific issues, responsibilities of independent legal representatives and direct legal representatives, what the court expects from you, and the capacity of a child to provide instructions. The stories of many children in care proceedings involve some level of abuse and trauma. Their circumstances are often complex. In many circumstances, the child involved in the care proceedings will have recently been removed from their families. They are likely to be in new environments with new people. They're likely to have spoken with a range of professionals, including caseworkers, and in some instances, police, doctors, psychologists, and other professionals. As the legal representative for these children, it's important to consider when and how you will meet with them and how you will put their views before the court. You should think about the way you communicate with these children, particularly when explaining legal concepts. In some instances, you may need to draw diagrams or use visual aids to communicate information to the child. With children that are older, you may need several meetings to explain more difficult concepts and information. It's important to think about what words and expressions you use so that they can understand these more technical concepts. We suggest keeping your letters to children short and using headings and plain English to explain what happened in court and the next steps. It may be appropriate to take an informal or conversational approach. Sometimes writing an email instead of a letter is easier for children to understand and respond to.
Throughout the proceedings, we expect you to have read the material in the file. You should be aware of recent information about issues that affect the child, for example, placement, contact, and incidents that may alter the likelihood of restoration. On the first occasion, you'll need to seek appointment as a representative for the child. Advise the court if you've received instructions from the child. You'll be asked whether you support any directions or orders the court is making. If you're unable to state your position, you should tell the court how long it will take to get instructions. Be conscious of the impact any decisions will have on the child you represent. At each appearance, consider the decisions the court must make and whether there's sufficient evidence to meet the statutory requirements for the court to make those decisions.
A child should always be given the opportunity to participate in care proceedings. The importance of this principle is enshrined in the United Nations Convention on the Rights of the Child. The Principles for the Administration of the Children and Young Persons Care and Protection Act 1998, which I will refer to as the Act throughout this training, highlight the importance of the participation of children. Section 9, subsection 2A, provides that one of the principles to be applied in the administration of the Act is that wherever a child can form their views on a matter concerning their safety and well-being, they should be given the opportunity to express those views freely. Section 10 of the Act deals with the principle of participation and provides the steps to be taken to make sure the child can participate in decisions that have a significant impact on their life. This is from the first notification that a child is at risk through to when a child who has been removed leaves care. A child should be able to participate in decisions that include plans for emergency or ongoing care, including placement, reviews of care plans, and contact with family or others. Participation means a child has the right to initiate intervention, access information, participate in decision making, and be able to express and have their views considered. By doing this, we ensure that children can be part of a process that determines major changes in their lives. For this reason, children expect and deserve a lot from us. We assist in making sure they understand and participate in the court process and the most important decisions impacting their lives. The importance of children's participation in proceedings is reflected in Legal Aid's quality standards. Jane is now going to address some specific provisions relating to Aboriginal and Torres Strait Islander families in care and protection matters.
As a lawyer representing Aboriginal and Torres Strait Islander children, it is important to be familiar with sections 11, 12 and 13 of the Act throughout proceedings. Section 11 states that Aboriginal and Torres Strait Islander people are to participate in the care and protection of their children and young people with as much self-determination as is possible. Section 12 states that Aboriginal and Torres Strait Islander families, kinship groups, representative organisations and communities are to be given the opportunity, by means approved by the Minister, to participate in decisions made under this Act that concern their children and young people. Section 13 provides for the placement of Aboriginal and Torres Strait Islander children and states that placement must occur in the following order: a member of the child's extended family or kinship group, a member of the Aboriginal or Torres Strait Islander community to which the child belongs, a member of another Aboriginal or Torres Strait Islander family residing in the vicinity of the child's usual place of residence, or a suitable person approved by the Secretary after consultation with the child's extended family or kinship group, or Aboriginal and Torres Strait Islander organisations that may be appropriate to the child. The case of Victorian Marcus considers the relationship between Section 13 and other sections of the Act, such as Sections 8 and 9, which are the objects and principles. Judge Marion stated that the purpose of Section 13 is to establish a placement regime which seeks to preserve the cultural identity of Aboriginal children and young persons. But the placement regime in Section 13.1 is not to be blindly implemented without regard to the other objects and principles of the Act set out in Sections 8 and 9. This case also emphasises the importance of encouraging and preserving a child's Aboriginal cultural identity, particularly when they are in a non-Aboriginal placement.
As members of the Care and Protection Panel, you'll be asked to represent children as either an independent legal representative or a direct legal representative. The Court appoints legal representatives for children under Section 99 of the Act. Generally, the court will appoint an independent legal representative for a child under the age of 12 and a direct legal representative for a child over the age of 12. The court appoints an independent legal representative for a child under 12 years old because the court presumes they are not capable to provide proper instructions. However, this presumption is rebuttable. The court can also withdraw its leave for a lawyer to appear at any time and for any reason. Examples of this include when a child indicates they don't want to be represented by the lawyer, or where the court doesn't require the assistance of a legal representative. Section 99D of the Act outlines the role of the independent legal representative and the direct legal representative. Responsibilities common to both roles are ensuring that the child's views are put before the court, adducing all relevant evidence and, when necessary, testing that evidence, progressing matters as quickly and efficiently as possible. There are key differences relating to the roles. If you're a direct legal representative, you act on the child's instructions. If you're an independent legal representative, you act in the best interests of the child. If you're an independent legal representative, you will also have additional responsibilities. These include presenting evidence that is relevant to the safety, welfare and well-being of a child, and making sure applications and submissions are considered appropriately and in the interests of the child. There are two significant responsibilities that are common to the role of the independent legal representative and the direct legal representative. The first of these is that the court expects you to put the child's wishes before them. You can do this in different ways. These include telling the court what the child's wishes are, preparing a views and wishes report, obtaining or using other evidence before the court, like a clinic or expert report where the child has expressed their wishes, and preparing an affidavit. You'll need to think about the best way to do this, as each case has individual circumstances. You can do this by developing a relationship with the child where they feel comfortable working with you. You should meet with the child as soon as possible and give them opportunities to meet with you regularly. Research shows that most children will want to have an ongoing relationship with you. Quite often, they may need more than one meeting with you before they are willing to speak about what they want to happen. It's important to remember that you're a stranger to them and you may be asking personal and difficult questions. It may take some time for the child to talk about these things and to be able to trust you. You should also think about how the child can contact you and that this is made as easy as possible for them. They should be able to easily get in touch with you and share information. Talk to the child about who could help them contact you if they can't do this themselves. This could be their caseworker, teacher, or carer.
You do not need to get instructions from the child before each court appearance, but you do need to think about how to involve the child or assist them to participate in the proceedings. Keep the child, or if appropriate their carers, informed about significant issues or decisions. What happens in court might change their life. For older children, you should get instructions or the view of a child before an important court appearance, where the court will be asked to make a decision that may affect the child. This includes a change to placement or parental responsibility, a contact application, the making of undertakings, a prohibition order, an assessment application, service referral, a joinder, leave, establishment, or final orders. If you're representing a young child or have decided not to meet a child, be prepared to explain to the court why you have not met them. At different stages in the proceedings, a child's wishes might change, and you should tell the court if they have changed. Present the true voice of the child. Other parties will often lead evidence of conversations with the child, and some of the evidence is contradictory. When meeting a child, weigh up the options for where to meet and who should attend the meeting, having regard to their needs. Your office provides a neutral environment for you to meet the child and their carers. Getting instructions from a child in their home can provide an opportunity to assess the dynamics of their home, see their environment, meet the carers and other members of the household. If you have concerns about your safety due to your attendance at the placement, you should identify whether these concerns can be mitigated. If not, meet the child somewhere else, or consider whether you can communicate by another means. Your observations of the child with their carers or in their home may be useful. In some cases, it may be appropriate to provide information about the placement in the statement of wishes. A photo of the child is a good reminder of why everyone is in court. If you're concerned about becoming a witness, there may be another method of providing the court with information. For example, through photos, subpoenas, a request for documents, or asking the caseworker to attend a home visit. Be careful of the material you file and the impact it may have on the relationship between the child, their parents, and their carers. Don't put the child in the firing line. If you see something of concern, do something about it. Be purposive. What's the purpose of the jurisdiction? It's about making decisions in the best interests of the safety, welfare, and well-being of each child. Think of it as identifying and managing risk of harm. Whenever decisions are made throughout the proceedings, you should always be prepared to make submissions about the risks to the child and options for mitigating those risks. Remember, this includes the risks of remaining in a placement as well as the risks of being removed from their home, with consideration of their relationships with their siblings, their connection to school, their cultural identity and local supports. Be strategic and contribute to court and dispute resolution conferences courageously but unemotionally. Think outside the square and find some solutions that might improve the life of your client.
The second of these key responsibilities as an independent and direct legal representative is to make sure that all relevant evidence is adduced and tested. When fulfilling your responsibilities of adducing relevant evidence, it starts from the beginning of a matter and continues all the way through to final orders. We'll now discuss the ways you can meet your obligations and be proactive as a child representative. If you're acting as a direct legal representative, you'll only need to take these steps when you have instructions to do so.
There are at least 10 people who know the kids better than we do, and likely more. Family members, teachers, health practitioners, police, neighbours, friends and service providers rarely provide evidence except through subpoenaed documents. You can't talk to everyone, and you shouldn't subpoena everyone, but if you turn your mind to the day-to-day experiences of the child, you'll realise that someone may know something that could help the court determine the best outcome for them. Remember, there is no property in a witness. Identify the issues that will decide the case, then consider whether information exists that may shed light on those issues. Get the information. Acute episodes of mental distress will have resulted in presentations to hospital, so subpoena the health authorities. Signs of neglect and poor school attendance will have been recorded by the school. Family violence will often be captured in police records. Remember, some of the records may be interstate. If the allegations against the parents indicate a likely history of similar issues, but it's not borne out in New South Wales records, the evidence may be available in a criminal record from another state. If you've crystallised the relevant issues in the proceedings, you'll be able to identify the legitimate forensic purpose served by issuing a subpoena and can issue subpoenas to appropriate services. You may find that subpoenaed material identifies a trail of service providers such that you need to issue further subpoenas. Subpoenas cannot and should not be a fishing expedition. They're expensive and time-consuming for those who prepare them and those who receive them. Narrow the period of time as required to address the issue. The agency with case management responsibility and any funded service providers who've worked with the family will have information relevant to the court's decision. Check whether you need permission from the department to talk to the service, and if so, get their permission or ask them to request information from the service about relevant issues. You may not need to do all of this on your own. Talk to the other parties about who's issuing which subpoenas and share the workload between you. Don't forget, your client may one day make a Freedom of Information request to access the documents. Check the content's accurate, ensure the wording's appropriate, and ensure their position statement reflects their position in terms they can reconcile in the future. Their relationship with family members will extend far beyond the period in which the court has jurisdiction. As an independent legal representative or direct legal representative, your role is to safeguard the child or young person's interests. You may need to check whether the department has taken all necessary steps to communicate with parents, to engage them, to provide appropriate supports with regard to their cultural background, cognitive ability, and any disabilities. You may need to push the department to undertake thorough family finding before placing a child in foster care.
There will be matters where the court won't need expert evidence to determine what is in the child's best interests, but there will be plenty of cases where it does. In these cases, you should carefully consider the issues in the case and whether it calls for expert evidence, and if so, what type of evidence is required. For example, a psychologist, psychiatrist, or social worker. In some cases, you may need to consider using experts outside of the clinic. These include cases involving allegations of non-accidental injury or medical neglect. It is important that you proactively seek and apply for a clinic assessment in appropriate circumstances and in line with sections 52 to 59 of the Act. As an independent legal representative, you act in the child's best interests. You're not required to take instructions from your client. You are required to put the child's expressed wishes before the court. You should make sure that the child's wishes put before the court are drawn from the evidence and not from your own personal view or opinion of the case. It's important to meet with children and keep them up to date with the progress of their matter. When making decisions on how often you contact the child and the level of detail to provide, it's important to think about minimising their trauma. For example, if the proceedings are having a negative impact on the child, you may decide to see them less frequently or provide alternate ways for them to be a part of the process. As a direct legal representative, you act on the child's instructions. Like any other client responsibility, when representing children as a direct legal representative, you must comply with the solicitor's conduct rules. Some of the most important rules to remember are: always provide clear and timely advice so your client understands relevant legal issues and can make informed choices. To not act as a mere mouthpiece of your client and exercise your forensic judgment independently. And deliver legal services competently, diligently, and promptly. It's important that you meet with the child before each significant court event so that they can give you their instructions, ask questions, and make informed decisions. Court documents are generally not prepared in a format that is easily read by children. There's likely to be sensitive information in these documents about a child and their family. This information may be difficult for the child to hear and may have a significant emotional impact upon them. Making decisions about whether to show a child court documents or how to show a child these documents should be determined on a case-by-case basis. When making a decision about whether to show a child court documents, you should think about whether the child will be able to understand the contents of the court documents, or whether the information will cause them distress. If you are going to show a child court documents, you can do this by telling them you've read the documents and you can talk to them about the important parts instead of them reading it all. Helping the child read through the documents and explaining the important sections to them. And ensuring a support person, such as a carer or psychologist, is available to see them after the interview if they're likely to be upset by the contents of the court documents.
The child's carer, caseworker, counsellor or teacher may provide information about the capacity of the child to understand and participate in proceedings, including whether they're likely able to process sensitive information. Talk to them. The care plan should reflect the child's situation at the time the matter is finalised. You should ensure your client's views are accurately reflected in the care plan and consider including the circumstances in which the child expressed their view. For example, who was with them when the care plan was developed? Last-minute amendments to the care plan might be frustrating, but they're a stitch in time. Clear directions will reduce conflict and anxiety and may avoid future litigation.
It's important to think about the ways you can assist with a child attending court if they have indicated they would like to. Ways to do this include arranging for them to attend part of the court appearance or dispute resolution conference, arranging for them to participate virtually or remotely, meeting them at court on a different day or time to their court appearance to show them the courtroom with no one in it. Use an image of a courtroom to describe what it looks like and what they should expect. You could use the picture in our Kids in Care brochure too. And discuss beforehand how the child can tell you if they're not feeling comfortable, wants a break, or would like to leave. Before a court appearance, it's important that you explain to the child that there may be times when the court will ask them to leave, and you should explain why. There is further information about how you can carefully manage these situations in Care and Protection Working with Children, a guide to best practice.
The right of a child to participate in proceedings extends to inviting the child to attend court. Older children may appreciate the experience to observe the proceedings. It may help them to understand the role of the court and each party, including the role of their own lawyer. Occasionally, a child likes to address the court. It can be empowering for the child, and it reminds everyone else that children are not made from paper. If the child's attending court or a dispute resolution conference, please let us know in advance. In order to support the child adequately, the court will need to know who else is attending court and their current relationship with the child. When a child attends court, it may be suitable to prioritise the matter in the list. Participants at dispute resolution conferences may be shuttled to manage risk factors. Alternately, if the court has notice, it can facilitate a child appearing by audio-visual link or telephone. The court should be reminded of any issues that might affect the child's capacity to participate in proceedings, such as disability, competency in English, or cultural differences.
Research shows protracted court proceedings have a detrimental impact on children. The Act calls for timeliness at various points to provide certainty to the child. Part of your job involves progressing matters as quickly and efficiently as possible. Of course, you should take this approach only if it's in line with the child's best interests. To do this, you should actively look for opportunities to take part in negotiations and settlement discussions.
Never lose sight of the interests of the child. For example, will lengthy proceedings affect placement, contact, attachment, or cause the child anxiety or stress? If so, identify the significant issues and work with the other parties in the court to reach a quick resolution. A strong voice on behalf of the child can assist settlement discussions. If delay will not impact the child, for example in a Section 90 application, consider whether information may be available to ensure the court makes the best decision and how long it will take to access that information. You may need to subpoena services, consult witnesses, and determine whether the existing application is in the best interests of the child, or if there's an alternative that might address any current issues the child may be experiencing in their care arrangement. If you have concerns about the current placement, you should consider whether interim undertakings or prohibition orders would reduce your concerns. If the child needs urgent intervention, medical, educational, or therapeutic, you should advise the court in the event the court wishes to record and monitor how the issues resolve. If there's any possibility that a dispute resolution conference might assist in identifying issues, mediating disagreements, reality testing parties, or enabling parties to properly participate in the process, then you should walk into court with a list of suitable dates. Any person who has a genuine interest in the welfare of a child and may be able to contribute to discussions at the dispute resolution conference may be invited to attend. Contact the Children's Registrar, who will consider whether they should attend and make appropriate arrangements. In court, only say what needs to be said. If you've prepared the case properly, this should be easy. Before you walk into court, you should know what the other parties want, what the child wants, and what's in the child's best interests. In addressing the court, consider the following 3 questions. What do you want the court to do? Where is the power of the court to do it? And why should the court do what you want? You need to find the balance between ensuring all relevant information is before the court and properly tested, while assisting the court to efficiently make the best decision. There should be no need to repeat material contained in the evidence or repeat questions asked by other advocates.
A child over 12 years old is presumed capable to provide proper instructions. This presumption will not be rebutted merely because the child has a disability. It's important that you meet with the child early so you can assess whether they have capacity to provide you with instructions. If you have concerns, then you will need to consider whether you should ask the court to appoint a guardian ad litem. Appointing a guardian ad litem may potentially deprive a child of their right to have a direct say. You should talk to the child about what you are doing and why. It's important to remember that just because a child may give you instructions that you don't agree with, for example, wanting to go home to mum and dad when circumstances don't permit, doesn't mean they don't have capacity to provide instructions. You can find further information relating to capacity in the Care and Protection Representing Parents training module. We hope this training enhances your knowledge and provides you with the resources and tools you need to represent some of the most vulnerable members of our community.